Introduce our keynote speaker this afternoon, Brian Egan, legal advisor of the Department of State. In so doing, I'm pleased to recall the close links between this society and legal advisors over the years. Several legal advisors, either before or after their tenure in that office, served as president of this very society. The ones I recall as my predecessors in this office and who had a deep influence on my own career include, in the memory of many others as well, John Stevenson and Monroe Lee, former presidents of this society. Many, if most, I hope I can say all of the legal advisors have been society members, including two who passed away since our last annual meeting and were honored at our assembly last night when we read the roster of our departed members. Those happen to be the two legal advisors under whom I served, and they also deeply influenced many of us in this room, Herbert Hansel and Robert B. Owen. Many, most, again, I hope I can say all have spoken at our annual meeting, for example, Abram Shays. And then there was that famous time that we had 7 at one blow. I don't remember which 7 they all were, but they might have included, some were all, of Davis Robinson, Abraham Sofair, Edwin Williamson, Conrad Harper, the late David Andrews, William Howard Taft IV, John Bellinger may have been on that program, and on a different set of programs, Harold Hongju Ko. We've had acting legal advisors, Michael Matheson, Joan Donahue, and Mary McLeod, who all have addressed this gathering. The American Society has provided a forum for important policy addresses by the legal advisors, including among those I've just named. We've also had the legal advisors bring before this gathering incumbent secretaries of state, for example, as John Bellinger did by bringing Secretary of State Condoleezza Rice. Legal advisor Harold Hongju Ko addressed this body more than once, including in a noted speech on international law and the use of force in 2010. I turn now to our speaker and his place in this distinguished lineage of legal advisors and the place or the linkages between the legal advisor's office and this body. In 1991, the American Journal of International Law published the report of a blue ribbon panel, which included all the then living former legal advisors, to study the role of the legal advisor in the process of foreign policy formulation. An objective, or at least a tacit motivation of that study, was to make recommendations for strengthening the influence of the legal advisor in the policy process. And one of those recommendations, which I will read, is the following. Should the legal advisor have prior experience in international law? ? And the recommendation was, in view of the unique responsibilities of the legal advisor regarding international law, it is highly desirable that the legal advisor have some previous professional training and experience in international law. And understanding and appreciation of international law is at the core of the legal advisor's role. Without the previous experience that gives such understanding and appreciation, a legal advisor may be less effective in carrying out the special responsibilities of the job. Moreover, a U.S. legal advisor without prior experience may be less effective in working with foreign legal advisors who typically have extensive previous experience in international law. And I'm very happy to say that the recommendation of the American Society of International Law in this regard has been honored in the appointments of the distinguished occupants of that office, including those whom we see sitting in the front row today, and certainly the most recently confirmed legal advisor and our keynote speaker today meets those qualifications. Brian Egan was confirmed as the legal advisor at the U.S. Department of State on February 12th, 2016. I want to add to the script, and it was worth waiting for. Prior to that, he served for over 4 years as Deputy Legal Advisor to the National Security Council, and then as Legal Advisor to the National Security Council, a position that doubles as Deputy White House Counsel. He is an experienced and able public international lawyer, widely known and respected in the Beltway's national security community, and indeed far beyond. He previously worked at the Justice Department and was a senior assistant general counsel for enforcement and intelligence at the Treasury Department. He worked in private practice for 5 years in DC and spent 4 years at the legal advisor's office. making him one of the first career lawyers in L to become legal advisor since Green Hackworth, who went on to serve as U.S. Judge on the International Court of Justice. So I hope that you will agree with me that our keynote speaker today indeed satisfies this high standard to which we hold all speakers at our annual meeting, that they be expert in our subject, and we invite you to the podium.
Thank you very much to Lori, to Mark, and to the entire ISIL team for inviting me here today. I am truly honored and humbled to be here before you all today. I'm here today to talk about some key international law aspects of the United States' ongoing armed conflict against the Islamic State, or ISIL, or ISIS, or Daesh, depending on your preference. In so doing, I'm following in the footsteps of others who have gone already to some lengths in recent years to explain our government's position on key aspects of the law of armed conflict. This, of course, includes most prominently President Obama in his 2013 speech at the National Defense University and his 2014 remarks at West Point. A number of other administration lawyers have spoken on these topics, including my predecessor, Harold Hanju Koh, former Attorney General Holder, and the former Defense Department General Counsels Jay Johnson and Stephen Preston, with Stephen speaking at this event last year. The Defense Department's recent promulgation of its Law of War Manual has also made a significant contribution to the public discourse on these issues. Some have said, however, and not unreasonably, I think, that our legal approach to the counter-ISIL conflict has been one of the, quote, most discussed and least understood, unquote, topics of U.S. practice in recent years. And thus, I come with a couple of goals. First, at the risk of disappointing some of you at the outset of this talk, I suspect and I really hope that much of what I will say today will not be surprising. I also hope, however, that these remarks will provide some clarity and help you understand better the U.S. international law approach to these important and consequential operations. Suffice to say that international law does matter a great deal in how we as a country approach counterterrorism operations. Prior to my confirmation, I served as the Deputy White House Counsel and Legal Advisor to the National Security Council for nearly 3 years. And based on my experience in that position, I can tell you that the President and his national security team have been guided by international law in setting the strategy, all aspects of the strategy really, for the approach to defeating ISIL, including counterterrorism operations. I can also attest personally with some battle scars to show it that the President cares deeply about these issues and that he wants to be sure that he understands them and he's not afraid to ask questions about them when he does not. So to start really from first principles, the United States complies with the international law of armed conflict in our military campaign against ISIL, as we do in all armed conflicts. We comply with the law of armed conflict because it is the legal obligation of the United States to do so. We do so because we have a proud history of standing for the rule of law, because it is essential to building and maintaining our international coalition in this fight, because it enhances rather than compromises our military's effectiveness, and because it is the right thing to do. I do not mean to suggest that identifying and applying the key international law principles to this fight is easy or without controversy. The United States is engaged in an armed conflict with a non-state actor that controls significant territory in circumstances in which multiple states and non-state actors also have been engaging military operations against this enemy, against other groups, and against each other in some cases for several years. These conflicts raise novel and difficult questions of international law that U.S. lawyers in the United States are called on to address, sometimes literally on a daily basis in conducting operations. Of course, we're not alone in stressing the importance of international law. It is also vitally important to other states. And as the President's counterterrorism strategy, including against ISIL, has prioritized the development of partnerships with those who share our interests, I submit that it is increasingly important for the United States to engage in what others have called legal diplomacy with those countries with which we partner, as well as with those with whom we may not see eye to eye. Our ability to engage and to work with partners can, and often does, turn on international law and international legal considerations. We want to work with partners who will comply with international law, and our partners expect the same from us. In this way, international law serves as a critical enabler of international cooperation and joint action on a full range of matters beyond the ISIL fight, from the mundane to those that hit the front pages, such as the Iran nuclear deal, efforts to promote peace in Syria, maritime claims in the South China Sea, data privacy and surveillance, and others. I'll address 3 topics in my remarks. First, I will attempt to explain in greater detail the United States' international legal basis for using force against ISIL and some of the key rules of the law of armed conflict that apply to our fight against ISIL. Second, I will address how law of armed conflict-related considerations arise in the context of partnered operations, an area in which legal diplomacy is particularly critical. And third, I will address the interplay between law and policy in the conduct of hostilities by the United States, and particularly those undertaken under the presidential policy guidance that the President signed on May 22nd, 2013, known as the PPG. So to start, I will begin with the United States international law justification for resorting to the use of force, or the jus ad bellum. As I mentioned a few minutes ago, the United States armed conflict with ISIL is taking place in a complicated environment, one in which a non-state actor, ISIL, controls significant territory, and where multiple states and non-state actors have been engaging in military operations against ISIL, other groups, and each other for several years. Unfortunately, this scenario is not unprecedented in today's world. ISIL and Syria resemble other countries where multiple armed conflicts may be going on simultaneously, countries like Yemen and Libya. In such complex circumstances, states can potentially find themselves in more than one armed conflict or with multiple legal bases for using force. This complexity is why it is all the more important that we are clear and systematic as government lawyers and as governments in our thinking through how jus ad bellum principles for resorting to force apply to our actions and what use of forces those principles permit. The UN Charter, as many of you know, identifies the key international law principles that must guide state behavior when considering whether to resort to the use of force. Article 2.4 of the UN Charter provides in relevant part that all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state. Article 51 of the UN Charter, on the other hand, specifies that nothing in the present charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs. Thus, the UN Charter recognizes the inherent right to resort to force in individual or collective self-defense. And similarly, the Charter does not prohibit an otherwise lawful use of force when undertaken with the consent of the state upon whose territory the force is to be used. So as a matter of international law, the United States has relied on both consent and self-defense in its ongoing conflict against ISIL. Let's start with ISIL's ground offensive and capture of Iraqi territory in June 2014, and the resulting decision by the United States and other states to assist with a military response. Beginning in the summer of 2014, the United States' actions in Iraq against ISIL have been premised on Iraq's request for and consent to the United States and coalition military action against ISIL on Iraq's territory in order to help Iraq prosecute the armed conflict against the terrorist group. Upon commencing airstrikes against ISIL in Syria in September 2014, the United States submitted a letter to the UN Security Council explaining the international legal basis for our use of force in Syria in accordance with Article 51 of the Charter. As that letter explained, Iraq had made clear it was facing a serious threat of continuing attacks from ISIL coming out of safe havens in Syria, and had requested that the United States lead international efforts to strike ISIL in Syria. Consistent with the inherent right of individual and collective self-defense, the United States initiated necessary and proportionate actions in Syria against ISIL. The letter from the United States also articulated the position that Syria was unable or unwilling to effectively confront the threat that ISIL posed to Iraq, the United States, and our partners and allies. Thus, although the United States maintains an individual right of self-defense against ISIL, it has not relied solely on that international law basis in taking action against ISIL. In Iraq, U.S. operations against ISIL are conducted with Iraqi consent and in furtherance of Iraq's own armed conflict against that group. And in Syria, U.S. operations against ISIL are conducted in individual self-defense and the collective self-defense of Iraq and other states. To say a few more words about self-defense. First, the inherent right of individual and collective self-defense recognized in the UN Charter is not restricted to threats posed by states, nor is the right of self-defense on the territory of another state against a non-state actor such as ISIL something that developed in recent years or after 9/11. To the contrary, for at least the past 200 years, states have invoked the right of self-defense to justify taking action on the territory of another state against non-state actors. As but one example, the oft-cited Caroline incident involved the use of force by the United Kingdom in self-defense against a non-state actor located in the United States. Although the precise wording of the justification for the exercise of self-defense against non-state actors may have varied, the acceptance of this right has remained constant over time. Under the jus ad bellum, a state may use force in the exercise of its inherent right of self-defense, not only in response to armed attacks that have occurred, but also in response to imminent ones before they occur. When considering whether an armed attack is imminent under the jus ad bellum for purposes of the initial use of force against a particular non-state actor, the United States analyzes a variety of factors, including those identified by Sir Daniel Bethlehem in the enumeration he set forth in the American Journal of International Law, the ASIL's own in-house publication in 2012. Those factors include the nature and immediacy of the threat, the probability of an attack, whether the anticipated attack is part of a concerted pattern of continuing armed activity, the likely scale of the attack, and the injury, loss, or damage likely to result therefrom in the absence of mitigating action, and the likelihood that there will be other opportunities to undertake effective action in self-defense that may be expected to cause less serious collateral injury, loss, or damage. The absence of specific evidence of where an attack will take place or of the precise nature of an attack does not preclude a conclusion that an armed attack is imminent for purposes of the exercise of the right of self-defense, provided that there is a reasonable and objective basis for concluding that an armed attack is imminent. Now, in the view of the United States, once a state has lawfully resorted to force in self-defense against a particular armed group following an actual or imminent armed attack by that group, it is not necessary, as a matter of international law, to reassess whether an armed attack is imminent prior to every subsequent action taken against that group, provided that hostilities have not ended. Under the PPG, however, the concept of imminence plays an important role as a matter of policy in certain U.S. counterterrorism operations, even when it is the U.S. position that it is not legally required. I'd also like to say a few words on how state sovereignty and consent factor into the international legal analysis when considering the use of force. President Obama has made clear that, quote, America cannot take strikes wherever we choose. Our actions are bound by consultations with partners and respect for state sovereignty. This is true of our operations against ISIL, just as has been true in our non-international armed conflict against al-Qaeda and associated forces. Indeed, under the jus ad bellum, the international legal basis for the resort to force in self-defense on another state's territory takes into account state sovereignty. The international law of self-defense requires that such uses of force must be necessary to address the threat giving rise to the right to use force in the first place. States, therefore, must consider whether unilateral actions in self-defense that would impinge on a territorial state's sovereignty are necessary, or whether it might be possible to secure the territorial state's consent before using force on its territory against the non-state actor. In other words, international law not only requires a state to analyze whether it has a legal basis for the use of force against a particular non-state actor, which I'll call the against whom question, but it also requires a state to analyze whether it has a legal basis to use force against that non-state actor in a particular location, which I'll call the where question. It is with respect to this where question that international law requires that states must either determine that they have the relevant government's consent, or if they must rely on self-defense to use force against a non-state actor on another state's territory, determine that the territorial state is unable or unwilling to address the threat posed by the non-state actor on its territory. In practice, states generally rely on the consent of the relevant government in conducting operations against ISIL or other non-state actors, even when they may also have a self-defense basis to use force against those non-state actors. And this consent often takes the form of a request for assistance from a government that is itself engaged in an armed conflict against the relevant group. This is the case, for example, with respect to ISIL in Iraq. Of course, the concept of consent can pose significant challenges in a world in which governments are rapidly changing, or have lost control of significant parts of their territory, or have shown no desire to address the threat. Thus, it sometimes can be a complex matter to identify the appropriate person or entity, for example, from whom consent should be sought. The US government carefully considers these issues when considering the question of consent, takes no two cases on its own and analyzes the facts in each case. In some cases, international law does not require a state to obtain the consent of the state on whose territory force will be used. In particular, there will be cases in which there is a reasonable and objective basis for concluding that the territorial state is unwilling or unable to effectively confront the non-state actor in its territory, so that it is necessary to act in self-defense against the non-state actor in that state's territory without the territorial state's consent. For example, in the case of ISIL in Syria, as indicated in the United States Article 51 letter, we could act in self-defense without Syrian consent because we had determined that the Syrian regime was unable or unwilling to prevent the use of its territory for armed attacks by ISIL. This unable or unwilling standard is, in our view, an important application of the requirement that a state, when relying on self-defense for its use of force in another state's territory, may resort to force only if it is necessary to do so. That is, if measures short of force have been exhausted or are inadequate to address the threat posed by the non-state actor emanating from the territory of another state. The unable or unwilling standard is not a license to wage war globally or to disregard the borders and territorial integrity of other states. This legal standard does not dispense with the importance of respecting the sovereignty of other states. To the contrary, applying the standard ensures, I would submit, that the sovereignty of other states is respected. Specifically, applying the standard ensures that force is used on foreign territory without consent only in those exceptional circumstances in which a state cannot or will not take effective measures to confront a non-state actor that is using its territory as a base for attacks and related operations against other states. Nor does the unable or unwilling standard dispense with the requirement to comply with the law of armed conflict, including the key principles of necessity and proportionality. To say a little bit more about how we think about the unable or unwilling standard. With respect to the unable prong of the standard, inability perhaps can be demonstrated most plainly, for example, where a state has lost or abandoned effective control over the portion of its territory from which the non-state actor is operating. This is the case with respect to the situation in Syria. By September 2014, the Syrian government had lost effective control of much of eastern and northeastern Syria, with much of that territory under ISIL's control. Shifting topics a bit, in the next few minutes, I'd like to shed some light on the jus in bello, the legal rules that we follow in carrying out the fight against ISIL. As a threshold matter, some of our partners have asked us how we classify the conflict with ISIL, and thus what set of rules applies. Because we are engaged in an armed conflict against a non-state actor, our war against ISIL is a non-international armed conflict, or NIAC. Therefore, the applicable international legal regime governing our military operations is the law of armed conflict covering NIACs. Most importantly, Common Article 3 of the 1949 Geneva Conventions, and other treaty and customary international law rules governing the conduct of hostilities in non-international armed conflicts. The rules applicable in NIACs have received close scrutiny since the September 11th attacks within the US government, in our courts in the context of ongoing litigation concerning detention and military commission prosecutions, and in the expanding and ever more sophisticated treatment that these issues receive in academia. I would like to clarify briefly some of the rules that the United States is bound to comply with as a matter of international law in the conduct of hostilities during NIACs. In particular, I'd like to spend a few minutes walking through some of the targeting rules that the United States regards as customary international law applicable to all parties in a NIAC. First, parties must distinguish between military objectives, including combatants on the one hand, and civilians and civilian objects on the other. Only military objectives, including combatants, may be the object of attack. Insofar as objects are concerned, military objectives are those objects which by their nature, location, purpose, or use make an effective contribution to military action, and whose total or partial destruction, capture, or neutralization, in the circumstances ruling at the time, offers a definite military advantage. The United States has interpreted this definition to include objects that make an effective contribution to the enemy's warfighting or war-sustaining capabilities. Third, feasible precautions must be taken in conducting an attack to reduce the risk of harm to civilians, such as, in certain circumstances, warnings to civilians before bombardments. Customary international law also specifically prohibits a number of targeting measures in NIACs. First, attacks directed against civilians or civilian objects as such are prohibited. Additionally, indiscriminate attacks, including but not limited to attacks using inherently indiscriminate weapons, are prohibited. Attacks directed at specifically protected objects, such as cultural property and hospitals, are also prohibited unless their protection has been forfeited. Also prohibited are attacks that violate the principle of proportionality, that is, attacks against combatants or other military objectives that are expected to cause incidental harm to civilians that would be excessive in relation to the concrete and direct military advantage anticipated. Moreover, acts or threats of violence, the primary purpose of which is to spread terror among the civilian population, are prohibited. To elaborate further and correct some possible misunderstandings regarding who the United States targets as an enemy in its ongoing armed conflicts, I'd like to explain how the United States assesses whether a specific individual may be made the object of attack. In many cases, the United States is dealing with an enemy who does not wear uniforms or otherwise seek to distinguish itself from the civilian population. In these circumstances, we look to all available real-time and historical information to determine whether a potential target would be a lawful object of attack. To emphasize a point that we have made previously, it is not the case that all adult males in the vicinity of a target are deemed combatants. Among other things, the United States may consider certain operational activities, characteristics, and identifiers when determining whether an individual is taking a direct part in hostilities or whether the individual may formally or functionally be considered a member of an organized armed group with which we are engaged in an armed conflict. For example, with respect to membership in an organized armed group, we may examine the extent to which the individual performs functions for the benefit of the group that are analogous to those traditionally performed by members of state militaries that are liable to attack. Is carrying out or giving orders to others within the group to perform such functions, or has undertaken certain acts that reliably indicate meaningful integration into the group. I'd like to turn next to discussing the international coalitions and other partnerships that are critical to the fight against ISIL and the legal diplomacy that helps facilitate and sustain those partnerships. 66 partners are engaged as part of the coalition that is degrading ISIL. In the course of building and maintaining that strong coalition, we have also sought to navigate legal differences and find common legal ground. Some of our allies and partners have different international legal obligations because of the different treaties to which they are party, and others may hold different legal interpretations of our common obligations. Legal diplomacy plays a key role in building and maintaining the counter-ISIL military coalition and fostering interoperability between its members. Legal diplomacy builds on common understandings of international law while also seeking to bridge or manage the specific differences in any particular state's international obligations or interpretations. Public explanations of legal positions are an important part of this legal diplomacy. The United States is not alone in attempting to provide such public explanations. Over the last 18 months, for example, 9 of our coalition partners have submitted public Article 51 notifications to the UN Security Council, explaining and justifying their military actions in Syria against ISIL. Though the exact formulations vary from letter to letter, the consistent theme throughout these reports to the Security Council is that the right of self-defense extends to using force to respond to actual or imminent armed attacks by non-state armed groups like ISIL. Those states' military actions against ISIL in Syria and their public notifications are perhaps the clearest evidence of this understanding of the international law of self-defense. More frequently, however, it is through private consultations that governments seek to understand each other's legal rationale for military operations. These private discussions help frame the public conversation on some of the central legal issues, and they are crucial to securing the vital cooperation of partners who want to understand our legal basis for acting. For example, there are times when the United States has sought the assistance of key allies in taking direct action against terrorist targets. Before these allies would aid us, the lawyers in their foreign ministries have sought a better understanding of the legal basis for our operations. Some of you are probably in this room. The prompt, compelling, and at times very early morning explanations provided by our attorneys can be crucial to advancing and enabling such operations. These conversations also go the other way. The United States' commitment to upholding the law of armed conflict also extends to promoting law of armed conflict compliance by our partners. In the campaign against ISIL and beyond, coalitions and partnerships with other states and non-state actors are increasingly prominent features of current U.S. military operations. When others seek our assistance with military operations, we ensure that we understand their legal basis for acting. We also take a variety of measures to help our partners comply with the law of armed conflict and to avoid facilitating violations through our assistance. Some examples of such measures include vetting and training recipients of our assistance and monitoring how our assistance is used. Now, some have argued that the obligation in Common Article 1 of the Geneva Conventions to ensure respect for the conventions legally requires us to undertake such steps and more vis-a-vis not only our partners, but all states and non-state actors engaged in armed conflict. Although we do not share this expansive interpretation of Common Article 1, as a matter of policy, we always seek to promote adherence to the law of armed conflict generally and to encourage other states to do the same. And as a matter of international law, we would look to the law of state responsibility and our partners' compliance with the law of armed conflict in assessing the lawfulness of our assistance to and joint operations with those military partners. Finally, I'd like to touch on the interplay between law and policy when the United States takes lethal action in armed conflicts, and how the United States often applies policy standards that exceed what the law of armed conflict requires. As a matter of international law, the United States is bound to adhere to the law of armed conflict. In many cases, the United States imposes standards on its direct action operations that go beyond the requirements of the law of armed conflict. For example, the US military may impose an upper limit as a matter of policy on the anticipated number of non-combatant casualties that is much lower than that which would be lawful under the rule that prohibits attacks that are expected to cause excessive incidental harm. Additionally, although the United States is not a party to the 1977 Additional Protocol 2 to the 1949 Geneva Conventions, and therefore not bound to comply with its provisions as a matter of treaty law, current US practice is already consistent with the protocol's provisions, which provide rules applicable to states parties in non-international armed conflicts. This treaty, Additional Protocol 2, is a treaty that the Reagan administration submitted to the Senate for its advice and consent to ratification, and every subsequent administration, including this one, has continued that support. I'd like to focus my comments on the next few minutes on another area where law and policy intersect: US operations to capture or employ lethal force against terrorist targets outside areas of active hostilities. In addition to the law of armed conflict, these operations are governed by policy guidance issued by the President in 2013. This policy guidance, known as the PPG, reflects this administration's efforts to strengthen and refine the process for reviewing and approving counterterrorism operations outside of the United States and, quote, areas of active hostilities. The phrase areas of active hostilities is not a legal term of art. It is a term that is specific to the PPG. And for the purposes of the PPG, the determination that a region is an area of active hostilities takes into account, among other things, the scope and intensity of the fighting in the relevant area. The administration currently considers Afghanistan, Iraq, and Syria to be areas of active hostilities, which means that the PPG does not apply to operations in those states. Substantively, the PPG imposes certain heightened policy standards that exceed the requirements of the law of armed conflict for lethal targeting. The President has done so out of a belief that implementing such heightened standards outside of hot battlefields is the right approach to using force to meet US counterterrorism objectives and to protect American lives consistent with our values. Of course, the President retains authority to take lethal action consistent with the law of armed conflict, even if the PPG's heightened policy standards may not be met. But in every case in which the United States takes military action, whether in or outside an area of active hostilities, we are bound to adhere, as a matter of international law, to the law of armed conflict. This includes, among other things, adherence to the fundamental law of armed conflict principles of distinction, proportionality, necessity, and humanity. The administration has already identified elsewhere a number of the aspects in which the PPG imposes policy standards for the use of lethal force in counterterrorism operations that go beyond the requirements of the law of armed conflict. I'd like to focus on one key aspect here. The PPG establishes measures that go beyond the law of armed conflict in order to minimize risks to civilians to the greatest extent possible. In particular, the PPG establishes a threshold of near certainty that non-combatants will not be injured or killed. This standard is also higher than that imposed by the law of armed conflict, which contemplates that civilians will inevitably and tragically be killed in armed conflict. In addition, with respect to lethal action, the PPG generally requires an assessment that capture of the targeted individual is not feasible at the time of the operation. The law of armed conflict does not itself impose any such least restrictive means obligation. Instead, combatants may be targeted with lethal force, provided that they are not out of the fight due to capture, surrender, illness, or injury. I hope that this short discussion of the PPG and other distinctions between law and policy has given you a somewhat better understanding not only of the differences between the legal and policy constraints on US lethal targeting, but also better appreciation of some of the lengths that this government has gone to attempt to minimize harm to civilians outside of hot battlefields, while also taking the direct action necessary to protect the United States and our partners and allies. In closing, I'll speak to a final aspect of legal diplomacy, one which my predecessors have emphasized in their public remarks as well. As legal advisor, one of my roles is to serve as a spokesperson for the US government on the importance and relevance of international law and how the US government interprets, applies, and complies with international law. Part of our legal diplomacy is carried out with our foreign counterparts behind closed doors, but public legal diplomacy is a critical aspect of our work as well, as my predecessors, several of whom are in the audience today, have so capably and ably demonstrated. It is not enough that we act lawfully or that we regard ourselves as being in the right. It is important that our actions be understood as lawful by others, both at home and abroad, in order to show respect for the rule of law and promote it more broadly, while also cultivating partnerships and building coalitions. Even if other governments or populations do not agree with our precise legal theories or conclusions, we must be able to demonstrate to others that our most consequential national security and foreign policy decisions are guided by a principled understanding and application of international law. I hope that I have succeeded in providing some clarity today on the United States approach to international law in the counter-ISIL campaign. I am confident, however, that I have not answered all of your questions. And we will seek some opportunities to provide additional clarity on these issues in the months ahead. In the meantime, I've reserved the remainder of my time for questions, and I'd welcome them. So thank you.
This is really a very special opportunity. In the few minutes before the lecture began, I mentioned to Mr. Egan that Justice Breyer last night had a technique for taking questions and then just not answering them. But we will let you call on however you like, and I think we have microphones. And please, if you'd like to come forward and feel free out of this vast sea of people who want to question you. And also, I'm sure that out of the several hundred law professors in the room, all of their Monday classes will be part of the continuing dialogue in the public diplomacy.
Great.
So.
All right.
Well, hi, I'm not a law professor. I'm Charlie Savage of the New York Times. Thank you for the remarks, Brian. Sometimes I play one on TV. I have two quick questions that I hope you might be able to provide some clarity on about things that have confused me, at least. Okay. So I'll just rattle through them rapidly. One, on your clarification of the zone of active hostilities and where the PPG does and does not apply. Does tribal Pakistan count as an extension of Afghanistan for the purpose of the PPG not applying, or does it count as a not hot battlefield where the PPG does apply? And secondly, on the military age males thing. Now, I haven't written this, but my colleagues at the Times first wrote about that in 2012, and I immediately began hearing pushback from people in positions not unlike you've held in recent years that that wasn't correct. But then it seemed to have been confirmed in the leaked drone papers published by The Intercept. And my understanding of it, it was less about well, if someone's a military-age male near a target, they are themselves a valid target, an ex-ante calculation. But it's more about, after the fact, how do we calculate collateral damage? If it's the case that some military-age males are dead near the strike zone, and that is all that is known about them, are they counted as collateral damage by virtue of that, or are they counted as enemies killed in action by virtue of that? And I would note that the drone papers showed that in a 13-month period of JSOC targeting, there were 35 targets killed and 219 bystanders killed as part of those targeting, and all 219 were categorized as enemies killed in action. Thank you.
Okay, thanks, Charlie. I'll try to hit both of those questions. With respect to the first, the question of area of active hostilities, when I mentioned Afghanistan, I think sometimes others have referred to the Afghanistan-Pakistan border region as being part of what we talk about with respect to Afghanistan. Secondly, on the issue of military-age males, it is not the case that a military-age male is considered a combatant solely by virtue of his being a military-age male. And I think that would apply both to assessments prior to a strike and assessments taken after action reports after a strike. So there are a variety of factors that are looked at in both cases, but it's not that one's military-age male status on its own would suffice.
I am a law professor. My name is Mary Ellen O'Connell from the University of Notre Dame. First, let me thank you for coming and being so frank with us on the administration's policies and its current legal justifications. And maybe I'll start by saying how very impressed I am with how much the Obama administration has done to move away from the global war on terror by ending the use of torture and by attempting to end arbitrary detention at Guantanamo Bay. Among the policies that were initiated during the Bush administration, the one that the Obama administration continues and that you've spoken of is targeted killing in the counterterrorism context. And I remain quite puzzled that this quite egregious aspect of the post 9/11 response remains. Let me be precise about my concerns on two of the key legal doctrines that you've used to try to justify the widespread killing with drones, cruise missiles, commando units, and so forth. And that's in particular unable and unwilling, that alleged doctrine, and also the PPG, the creation of the US's own in-house rules for lethal use of force outside what you've called hot battlefields. Sir Daniel Bethlehem, in his proposals where you say you have looked for the underpinning of the unable, unwilling doctrine, in the American Journal, he makes very clear this is just a proposal, it's not what the law says. And there were about a dozen of us who responded from a variety of perspectives, but I think the one most important is that that's simply not what the UN Charter allows. Article 51 says nothing about being able to attack states that are unable or unwilling to take care of a problem. And as we pointed out to Daniel in that discussion, the UN Charter isn't changed by contrary state practice. I see Lori getting up, so I'll come very quickly to the point. But I would say the same thing.
I'm only getting up to publicize the American Journal of International Law and because you very eloquently wrote there along with many of the others. And so if you have a question, I think
my question is, given that unable and unwilling is not part of international law, or what am I missing that somehow the UN Charter has been changed on that point? And also, where can the United States find the authority to make up rules to use lethal force outside basic human rights law and the United Nations Charter?
Well, thank you for your questions. Understand that there are a lot of different views on many of these topics, and that I appreciate the sentiment behind your questions. Just on to take the second question first, and just to be as clear as I can, the PPG is not a substitute for the international law framework that would otherwise apply to the use of force. Our use of force is governed by the law of armed conflict in all cases, whether or not the PPG applies. The PPG, in certain circumstances, imposes additional limitations on the United States' use of force beyond the law of armed conflict, but it is not a substitute or replacement for the LOAC itself. On unable or unwilling, you're absolutely correct in that this position is one that is not shared universally. It's not been articulated by all of our partners. We're not alone in taking this position. I think if you look at the Article 51 letters that have been filed by a number of our partners in the context of Syria, you will see others referring to unable or unwilling in their letters. It's a doctrine that we follow. We take great care to try to cabinet it in to ensure that when policymakers are making decisions about the use of force, that they are really thinking about whether the relevant state is truly unable or unwilling to effectively address the threat that has given rise to the right of self-defense. But I think I would submit that looking back through history, there are numerous cases which fit into the unwilling or unable paradigm, and it's an important part of the law of self-defense when used appropriately. Thank you. Please.
Hi, I'm Nudrat Piracha. I'm doing my STD at George Washington University, and I'm an intern at ICSID. My question is that on the one hand, you have a group which is deliberating and acting under the false belief that they are going to heaven for whatever they are doing. And on the other hand, you have a state which goes in another state and does all that destruction on the basis that there are weapons of mass destruction, and later apologizes, actually it was weapons of mass corruption. In both the cases, both parties acted under a false belief and innocent lives got lost. The first was an act of terrorism. The second, maybe some would say it was an act of intervention, but to your mind, how are the two parties different? How are their actions different?
So thank you for your question, and I'm not sure I fully captured it. I would say that our actions in all cases are governed by law, the law of armed conflict, both in terms of the initial decision as to whether a use of force is justified and as to the rules that would govern the use of force. And that's what sets us apart, and that's what's important for us to maintain clarity on as a government, as a country, that it provides us a lodestar to which we can point others to in circumstances of conflict, which often have tragic results. But I think our compliance with the law of armed conflict across the board is what sets us apart. Thank you. Yes, please.
Hugo Cagüeñas Muñoz from George Washington University too.
Right.
I have a question about the rules of customary international law. Specifically, during your presentation, you refer to some concepts that reminds me, for example, the rule number 8 about the military objects. Which is the position of the Department of State in front of the rules of customary international law, specifically the rules that were identified by the Committee of the International Red Cross?
Thank you. Are you referring to the recent release by the ICRC of their commentaries?
So, International Committee of the Red Cross about the rules of customary international law.
So that's, thanks for that question. We are working our way through the commentaries, which are quite lengthy, and we are looking forward to engaging on those commentaries. I think they will be an important part of the discussion. We're not quite in a position to do so at this point, but we certainly anticipate taking that on in the coming months. On the discussion of Common Article 3, I think there were over 900 footnotes to that section alone. So please give us a little time, but we'd be happy to engage on those.
To clarify, no, I was referring to the rules of customary international. They were identified, for example, among the process of academic process from the ICRC they identified some rules of customary international. So you, as a general,
Yeah.
what is the approach in front of customary international law?
So the United States general approach to customary international law is to look for evidence of state practice and where that state practice is motivated by a sense of legal obligation. And we think that is the correct way to approach whether a rule has become customary international law, is to look at the practice of a state and whether it's become a common practice and whether the practice is undertaken pursuant to a sense of legal obligation. So that's how we would approach the issue of whether a rule or a norm has become customary international law. Yes.
This will be the last question. I think we're just at about your 6
Great.
o'clock mark.
Okay.
This will be the last one?
Great.
Hey, sir, thank you for coming. That was very interesting. My name is Doug Cantwell. I'm an international law fellow here at ASIL, and I'm on reserve as a judge advocate in the Navy.
Great.
So this question is obviously in my personal capacity. I think Professor O'Connell raised some interesting points about whether the unable or unwilling standard is law currently. But I want to ask a question. Assuming for now that it is, I think you'll maybe get more questions on your definition of unable under that test. I assume that the theory is that the Assad government is unable because you didn't discuss unwilling, and that the argument was loss of effective control can be used to show that a government is unable to address a threat. But I'd like to hear more about the contours of what makes a state unable, how long would a state need to lose effective control of how large of an area, and importantly, who is going to determine that a state has lost effective control of an area? I think without more detail, it's a bit troubling, and it would be troubling to see that theory invoked by other states.
Thank you, and that's a good question, a fair question. I think that the reason that I focused in my remarks on the issue of control is I think the best enunciation of the United States position on this issue with respect to Syria is probably the Article 51 letter that we submitted in September of 2014. I think if you looked through all of the Article 51 letters that have been submitted, I think there have been 9, the theme of effective loss of control is one that permeates all of those letters, even for those states that don't talk about unable or unwilling. So some states, Canada, the UK, Turkey, talk about unable or unwilling. Others do not, but point to the effective loss of control of territory. I think Germany's letter does that, for example. And I think that the two ideas kind of converge in the inability prong, where a state has lost effective control of a significant part of its territory, which is under control of the non-state actor that is perpetuating the attacks. I think that is maybe the clearest example of an inability to effectively address the threat. I can't unfortunately provide more than that on this topic at this point, although it's something that I anticipate we'll be saying more about in the months and years ahead. It's going to be an important topic that for all of us as we think about NIACs and non-state actors going forward. All right.
So, do you have...
Great. Thank you very much for your questions, for your attention.
Thank you so much. Thank you so much. We are so pleased that you have chosen this forum for your very first public statement in capacity of legal advisor, and that you have given us such a detailed and really insightful look into the administration's legal positions as part of the public diplomacy in which you will continue to be engaged. So we're very privileged, and I am confident that there will be opportunities for those of you who would like to continue this discussion to apply to the editors-in-chief of the American Journal of International Law for perhaps the opportunity to contribute to an agora, and to the new publication Agile Unbound, which will, I'm sure, electronically host a forum for many views on these different points that you have raised. Now, I've been asked to make 3 announcements. The first is to note that a reception for the alumni of the Office of the Legal Advisor, and not only the alumni, but the current members of the Office of the Legal Advisor, will take place in the Thornton Room on the 11th floor beginning at 6:30. Second, we will encourage everyone, please come and attend the doubleheader, the White and Case ASIL ILSA reception, and the very special screening of the film All Rise, which should be, I think, of great interest to everyone in the present audience. And finally, we have, as a concurrent event, the New Professionals Networking Reception. So among those 3 receptions going on, beginning about half an hour from now, you will find much to choose from, and please continue these conversations there. Thank you very much.